saying Trump tried to influence the 2016 election, paying Stormy 130 G's. I think there's a new image of her going around. Have you seen that? I don't know if that's real or AI or what, but gosh, rough. Okay, this was like their consolation prize. They were so mad that he won that they had to come and just sentence him. Like, it's gonna feel so good to sentence him. He's gonna be a convicted felon. Okay, you guys lost everything.
Remember, I've said we will never have a socialist elected to any post in our country. I used to say that, and I was right. We skipped socialist and we put in a communist instead. That didn't work out too well.
Victory for President Trump on appeal. We're coming out of the Second Circuit, and this was a big one because Trump has been fighting for this for some time. This, of course, is in the case involving the criminal prosecution brought by Alvin Bragg, this guy, who brought in the trial Michael Cohen, a convicted perjurer, to run his mouth to talk about alleged payments to Stormy Daniels, who's also allowed to run her mouth with all her inconsistencies. And Trump said, why is this case being prosecuted by Judge Juan Merchan? Alvin Bragg is alleging that these are federal election crimes, so why are we in state court? Trump tried multiple times to do what's called remove the case from state court up into the federal courts, remove it on up, and they said no many times, until, of course, today. So here you can see the case, of course, the people of the state of New York, who, as we just saw from the last election, are lunatics, but they came after President Donald Trump. Here's what the court said. All right, rewind the clock. Let's go back to March 2023. A New York State grand jury indicted President Trump. Remember those 34 counts of falsifying business records. 1 felony for an invoice, 1 felony for a check, 1 felony for writing the check in your QuickBooks ledger. Multiple times, because Cohen was getting paid on monthly basis. So he got charged. The indictment said that Trump orchestrated an illegal scheme to influence the 2016 election by directing his lawyer, Cohen, the perjurer, to pay 130 grand to film star Stormy Daniels. Remember that? She didn't want to reveal an encounter with the president, allegedly. Trump sought to remove the criminal case against him. It got brought in New York State court, so he wanted to remove it up to federal court. He said the federal law says we can do this, but the district court at the time said no. She said, sorry, you can't do that. It doesn't fall within the purview of the statute. Following a state court jury trial in Judge Juan Merchan's courtroom with Cohen and Stormy and the rest of them, Trump was convicted on all counts, remember? After Trump's conviction, but before his sentencing, guess what happened? The United States Supreme Court came down and they issued their immunity decision that Judge Khan did not pause to consider. Remember, Judge Chutkan did this. We had 2 cases happening simultaneously. When Trump went into Judge Chutkan at the federal level and said, hey, I've got immunity and I'm going to appeal this all the way up to SCOTUS, she paused everything because she had to. But the same thing was going on at the state court level, and they said, we're not pausing anything. Are you kidding me? We have to get Trump convicted before the election comes down, or else we're going to lose, even worse than we did under Biden and Kamala's stewardship. So here they issued their decision. Trump thereafter sought leave to file a second, okay, so he says, hey, first time he tries to remove it, denied. Doesn't fall within the law. Second time he says, hey, Supreme Court just came down and said, just what I said, I have immunity. So he now says, let me remove again. But that was filed untimely, right? Because it was just outside of the permissible time. The trial's already over. And this establishes, he says, well, the other provisions establish a procedure of removal for good cause to say, hey, I can file late. I've got pretty damn good cause. The Supreme Court just came down and said, I was right. Now, Trump argued principally that the Supreme Court's intervening decision rendered the state's prosecution that is relating to his official acts as now being removable, okay? And Trump was prosecuted in this court for his official acts. They brought in Madeleine Westerhout. They brought in Hope Hicks, 2 government employees, to talk about what Trump was doing during his time as the president. So the district court denied leave, said, no, we're not removing this. This is staying with Alvin Bragg, concluding, among other things, that good cause was not shown in seeking a removal. And now the Court of Appeal says, wrong. We cannot be confident that in doing so, the district court adequately considered the good cause inquiry. Those issues include, but are not limited to, the impact of this. The Supreme Court just came down. That's pretty damn good cause. Now, the district court did not even consider whether certain evidence that was admitted to the state court even relates to immunized official acts. Didn't even think about it. Or whether evidentiary immunity transformed the state's case into one that was basically under the color of the presidency. The judge didn't consider a bunch of things, and so therefore we vacate the district court's order denying Trump's motion to remove or file the second notice of removal, and we send this right back down to her desk for a remand, for reconsideration of the motion consistent with this opinion. All now coming from the Second Circuit in a decision that is per curiam. It's the decision of the court. Here's more background on this. They say, all right, listen, the federal officer removal statute, it permits a defendant in a state criminal prosecution permission to remove the case to federal court. That's exactly what Trump was. Federal officer, the highest, who is being charged under the state for federal crimes. He says, hey, I was a federal official. They're prosecuting me for federal allegations. The federal court should hear that. Now, the statute's basic purpose is to protect the federal government. That's why we wrote it. 28 U.S. Code, section 1444-2A1. The statute's basic purpose is to protect the federal government from interference by state prosecutorial hacks like Alvin and Fannie and Letish to have to be hauled into state court when we have the supremacy clause. But there are rules that the defendant, in this case Trump, had to follow to take his case out of Alvin and Mercan's court up into the federal courts. Among them is the requirement that he files within 30 days. But even that requirement has a little play in its joints. On a showing of good cause, the court may still consider the removal. So this appeal from the president, we got to ask two basic questions. One, whether the state prosecution of then former President Trump was removable based on those statute. And two, whether the then former president actually showed good cause within the meaning of the statute to file a notice of removal well after his arraignment, his trial, and his verdict based on the decision from SCOTUS. And remember, Mercan knew that Trump was appealing these issues and he should have stopped it at the time, but he said, no, we don't have to do any of that. We're just going to move this forward. Those are federal claims. I don't care. Because the district court does not appear to have considered the important issues. Yeah, it doesn't appear. That's on you, judge. Bad judge. Doesn't appear that she even did her job at all and didn't consider the important issues relevant to removability of the underlying state prosecution because they didn't care. They had a mission. And this was before the election. We've seen how these federal judges have been acting in recent months ever since Trump actually took the White House. They were doing it before. This was like a nationwide injunction, right? Type of an action to, oh no, we can't hear this case. Alvin, you run with it. Why don't you take Matthew Colangelo, the number 3 at the Biden DOJ, who just left his office to go facilitate these prosecutions, and we'll just let the state handle it with acting Judge Khan Mercan. Says, now it's remanded, and you better reconsider this, judge, and do a good job this time, okay? In March 23, a New York State grand jury indicted Trump, 34 counts of false business records, saying Trump tried to influence the 2016 election, paying Stormy 130 G's. I think there's a new image of her going around. Have you seen that? I don't know if that's real or AI or what, but gosh, rough. Friends don't let friends make false allegations against other people, okay? Not even once. You'll turn into a meth head. Trump sought to remove the criminal case against him to federal court. The district court remanded the case to state court because it said, oh no, you can't remove this. These are state crimes. Alvin said, we're not even going to talk about federal charges. Then at the trial, he's like, well, we think it could be federal charges. Jury, pick a crime, any crime, and one of those is a federal crime. Following a nearly 7-week trial in state court, okay, and Trump was running for president, they shackled him down to the seats in the judge's chambers for 7 weeks in the middle of an election. So every time they come out and screech and shout about weaponization or retribution or whatever nonsense that comes out of their mouths, you can just point to this. They shackled the president down for 7 weeks in the middle of an election. Illegally. Case shouldn't even have been there. Should be removed. A jury convicted Trump on all 34 counts. On July 1, after Trump was convicted in this rigged court, but prior to the sentencing, okay, so the case is still open, the Supreme Court issued its presidential immunity decision, which was obviously how it was always going to come out, because how does everybody else have immunity except the president? Makes no sense at all. We already saw the Nixon precedent with civil immunity and all these other things. So the courts knew better, but they didn't want to hear it because they needed to convict him. In Trump, the Supreme Court case, the Supreme Court held that the president is absolutely immune from criminal prosecution for conduct that he's allowed to do. If he has the constitutional authority to do those things, you can't prosecute him for doing his job. Makes sense. But Judge Chutkan couldn't figure it out. Judge Mercan couldn't figure it out. They could figure it out. They just didn't care. Separation of powers, the court said in the Supreme Court, necessitate that there's at least presumptive immunity for criminal prosecution within the outer perimeter. And remember, there were the 3 buckets. One, if it is constitutionally dictated, the president can do it, he's absolutely immune. If he can make the argument that he has the authority to do that under the Constitution, it's presumptively immune. And the other side can show why it's not protected. And then, of course, if it's absolutely nothing to do with his job or role, then that would not be immune conduct. We have the 3 buckets, creating a spectrum. Most relevant here, the Supreme Court also said, even when an indictment alleges only unofficial conduct, prosecutors may not introduce evidence of the immune conduct. So if Alvin is saying there was a crime, then he can only talk about the allegations that create the crime, right? The facts and circumstances that would lead to the criminal charge. But if any of those actions, if any of that evidence is official business, you can't use it unless you can show it falls into that 3rd bucket that has no immunity. Now, in light of this decision, Trump then says, I'm totally vindicated. All these prosecutions were rigged because they brought in official acts evidence about how Trump was responding to the media as the president, clearly within his purview. This time, Trump sought to file a second leave. He says, hey, I got good cause now. Supreme Court says I'm 100% right. Now, he said, I know it's untimely. The rules say you got to file it immediately within 30 days. And I didn't do that because the case has been going on. We lodged our objection at the beginning, but Merchan didn't pause it. Judge Chutkan did pause it. Jack Smith tried to keep the case going until Judge Chutkan had to shut him up too. Say it's on appeal. I can't really do anything here. Among other things, he argued that the state's prosecution was related to his official acts, and that means the case is removable. Now, the district court denied it again. They say, sorry, your filing's late. You can't submit this one in my court, she said. He says, well, that's good cause. The law says if there's good cause, in this case, the Supreme Court, then I can do it. She said, no, sorry, like that one teacher or professor you had. After Trump's election as president in November 2024, what a glorious day that was, the state court imposed a sentence of unconditional discharge, right? Merchan said, I really can't penalize you at all. So no probation, no fines, no jail, no penalty, unconditional discharge. The most lenient sentence possible in light of the conviction, because all they wanted was that little mark on it, a scarlet letter. We're going to brand Trump a felon. Trump appealed his final judgment of conviction to the appellate courts, where the appeal remains pending. But Trump also is now saying, you should have let me remove this case up to federal court after the second notice was filed, after we had very good cause, because the Supreme Court said so. They go into part two. New York law, writes the Second Circuit Court of Appeals, obliterating the lower court judge, it makes it a first-degree felony for any person to make a false entry into business records. And of course, we were following the bouncing ball. Then they turned a misdemeanor predicate into a felony to commit another crime or to aid or conceal the commission thereof. A state grand jury charged Trump with 34 counts in violation of the law. Now, according to the indictment and the evidence that came out at trial, they said Trump orchestrated a scheme. Shortly before the election, they said Michael Cohen, a convicted perjurer, his lawyer, paid Stormy, another, in my opinion, liar, $130,000 to prevent her from publicizing an encounter. And the reason I say that is because Stormy Daniels wrote multiple times that there was no affair. It never happened. She said here many times, no affair right here. Remember, she wrote that January 30th, 2018. Over the past few weeks, everybody's bugging me about this. The fact of the matter is that this alleged affair, I denied it many times. She said I denied it 06, 11, 16, 17, and now again in 18. I'm not denying this affair because I was paid hush money, she says, as has been reported in overseas owned tabloids. I'm denying this affair because it never happened. It's her own writing, her own signature, all there. Then, of course, the election comes around, and so she needs to act in order to elevate her status by attacking somebody who the Democrats want to stop. So she's a liar, in my opinion. Following his client's instruction, Cohen, the lawyer, perjurer, then paid Daniels using a shell corporation. After the election, Trump reimbursed Cohen through a series of checks they allege to disguise each check as payment for legal services when it was really a campaign expenditure. The Trump organization maintained the records. There was no retainer agreement. And instead, according to the indictment, Trump was the one who caused his entities to falsify the business records to hide the criminal conduct. So then Trump, of course, April 4th was arraigned in the Supreme Court of New York in the sham prosecution. A month later, he filed a timely notice. He says, okay, they're saying I falsified the record, so I misclassified it. It's not a payment to a lawyer. It's a campaign expenditure. What governs campaign expenditures? Federal law. Oh, okay, because I'm running for federal office. So they removed it. They tried to. They told a lower level judge, they're charging me for crimes that I committed allegedly while I was the president. And many of the checks, I think all of them actually, were signed by him as the president. So the state moved to remand the case to state court. They said, no, this is not a federal crime. It doesn't involve any federal allegations. And after conducting an evidentiary hearing, remember Alvin Bragg went over there, or somebody from his team. I'm not sure he does anything actually other than talk and eat. But the district court concluded that Trump had failed to meet his burden of establishing removal because Alvin came in there, his office, and said many times, we're not charging him with any federal crimes at all. So it's a state case, so just leave it here, federal judge. It's not your business. She said, you're right. It isn't my business. She explained, she says, well, hush money paid to a film star is not related to his official acts, and it doesn't reflect in any way on the official duties. And so they said, it's none of our business. Yeah, but they're saying that it was a campaign expenditure while he was running for federal office. And as the president, he responded to that and explained himself in defense of the payments to Michael Cohen, and they brought all of that in as evidence against him, is the problem. Trump appealed the decision, but for reasons that are not clear on the record, dismissed it later, and the criminal trial began. On May 30th, a day into deliberations, the jury came back, 34 counts, Trump's guilty. Incredible. Then on July 1, before Trump was scheduled for sentencing, the Supreme Court came down. They issued their decision. In addition to providing for at least a presumptive immunity, okay, that we got three buckets, absolute, presumptive, and none. They say if it's within the outer perimeter of his responsibility, like if he can make the argument like, hey, nope, I got these broad powers. It's in here. Then he gets it. The court said that even evidence of the president's immunized official acts is inadmissible. Can't bring in Madeline, can't bring in Hopes, can't talk about all of the official acts. He's allowed to do those things. And they were using it to imply guilt. Because the intended effect of immunity would be defeated, if you're immune from the process. You're immune from that evidence from the trial. You can't just like say, oh, well, now that I've been found guilty, I'm going to pull out my immunity card. The process is the penalty. You're immune from the penalty from the process. Because the intended effect of immunity would be defeated, if the official acts could be scrutinized and you're like, we're going to convict you for doing what we elected you to do. The Constitution says you have to do this, and so now you're going to jail. What? It doesn't make any sense. The court explained evidence must be inadmissible, even when the indictment is saying, well, it's only alleging unofficial conduct. Okay, that's fine. Unofficial conduct you can prove with unofficial evidence. But if it's official business, then you can't bring it in. And they did that. Now, in light of this decision from the Supreme Court, Trump first moved in state court to dismiss the indictment. He said, hey, Juan, the con judge, I am right. You are wrong. Judge Chutkin got the same message, and that case was dismissed. It didn't proceed to trial. Now, here, the judge said, I don't really care, and continued with the conviction. When the state court judge, the con, denied it, Trump tried another tack. He said, hey, how about I go and just remove this case again because I've got good cause now. The Supreme Court just said I'm victorious. And he filed nearly 2 months after the Supreme Court another removal. And of course, there's a different section of the law, B1, governs the procedures for removal. They say you should file within 30 days. Hello. But if you have good cause, then you can file later. And there's a little bit of a delay. Like it would have been nice to have them, file that 10 days after the Supreme Court. Hey, oh my gosh, look what just happened. But motions take time and they had to research some things. So 2 months, not bad. The district court thus initially rejected the second notice. They said, sorry, this is untimely. It's not good cause. This is not even new. He waited 60 days or whatever she said. On September 3rd, however, Trump corrected the error and filed a motion to leave. Okay, so basically she says, sorry, before you can file your second notice of removal, you have to get permission from me to file a motion for leave to file a second notice. She's like, nah. And so he's like, all right, I'll do it. Now that is the motion issue on appeal, and Trump is going to win this one. Now the district court, they say, soon as Trump sent that in, she denied that motion in a brief order issued the same day. Didn't even read it. Just like, oh, Trump requested something? Nope, deny it. Do you want to read it? No. It's Friday. Are you kidding me? No, I don't want to read anything. So denied it the same day, probably hours or minutes. Describing many of Trump's challenges, she said, well, if he's unhappy about it, he can go to the state courts in New York and appeal over there. The district court said Trump had failed to show good cause. It's too late, sorry. She said, the Supreme Court doesn't say that anything that you're alleging affects my prior conclusion. The actual hush money payments, they were private. They were unofficial acts outside the bounds of executive authority. So she says, well, my original decision would have put those into that third bucket and signs it within minutes. Now, Trump appealed that to us, and that's where we are now. He moved in the district court for a stay, asked for an emergency stay, and again, they denied it. She said, no, sorry, there's no action. There has been no removal. None of this is proper. And by then, however, the state court, Judge the Con, adjourned sentencing until after the presidential election. He said, we'll postpone it. So in light of and then Trump won. In light of the adjournment, this court denied the emergency stay motion and said, sorry, you lose again. Okay, this judge, no, denied, until this one. Now on December 2nd, after his reelection, all the Democrat fraudsters all go, oh crap, we just tried to destroy him and he won anyways. Trump filed another motion, again, before the state court trial judge, the Con, that had presided over his criminal proceedings. He said, hey, you have to dismiss this now and vacate the verdict because I've got the Supreme Court and the presidency. The trial court denied that motion again, January 3rd, 2025, and scheduled sentencing for a week later. Remember this? Trump was the president-elect and had to go in and get sentenced by a maniac, corrupt judge, in my opinion, but declared that it was inclined to impose any sentence of incarceration. Of course not. He's the president-elect. What are you going to do? Trump then, as the president-elect, moved in the state appellate courts, and he wanted to stay the sentencing. They all denied it. Supreme Court had the final word. A day before, they said, you're getting sentenced. Okay, this was like their consolation prize. They were so mad that he won that they had to come and just sentence him. Like, it's going to feel so good to sentence him. He's going to be a convicted felon. Okay, you guys lost everything. The court held that the evidentiary violations can be addressed on the course of appeal and that we're not even going to sentence him bad. In light of the trial courts, we're going to impose unconditional discharge, no jail, no fine, no probation, no reporting, nothing. It's going to be a brief virtual hearing. Not even going to make him show up. On January 10th, the trial court sentenced Trump unconditional discharge, and guess what? Trump became the president 10 days later. Historic, our first felon president. 34 too. He probably is going to hold that for a long time. Nobody's going to beat that. that? On appeal, Trump argues that the district court erred. They screwed up. You should have let us remove this case, and you done goof. The state court says, and the state, in this case, Bragg and his goons, they respond. They say, all of this is moot, okay? The case is over. He's been convicted. There's nothing to remove anymore. The entire appeal is moot. They say, even if the appeal is not moot, Trump has no good cause. He can't file this notice for removal. And they say, well, sorry, Alvin. We conclude that the appeal is not moot. We vacate the lower judge's order that denied Trump's motion, and we remand this case back down to her to reconsider what she has done with her life and this case, and do a good job this time to reconsider Trump's motion. Now, the first question is whether the case is moot. A case becomes moot if there's no longer a case or controversy. The state says it's moot. Trump has already been sentenced, okay? The case is over. We got it through. There's nothing to remove anymore. The case is closed. But the state's argument in favor of finding that this case is moot assumes on the merits that a federal officer defendant can never remove as long as they have been sentenced. It's like as long as you get that TV outside the door without paying for it, as soon as you get past those little metal detectors, you're good. That's how this works? No, come on. Now, as discussed, this is an open question, and whatever we think of the obstacles that Trump faces in obtaining removal at this stage of his state criminal proceedings, it's not about mootness. At this stage, there is a controversy. Trump has at least some prospect of successfully removing the proceedings to federal court and obtaining the relief he seeks. We cannot say that he has no concrete outcome in the interest of this case. It's clearly still open. It's not moot. He's moving forward. Now, on the merits, the other question is whether the lower level judge erred in denying Trump's motion. And so we're going to review that to see if this judge abused her discretion. She did. A district judge abuses or exceeds discretion when it rests its decision on an error of law, or if there's a clearly erroneous factual finding, or if its decision cannot be located within the range of permissible decisions. The law says the following: file your thing within 30 days, but if there is good cause shown as to why you didn't file it within 30 days, like for example, the Supreme Court came down and vindicated you, then you may file the notice at a later time. Right? But you got to ask for leave. And the judge's like, well, you didn't ask me first for leave. You just filed it. Like, okay, fine. Here's our permission slip. Can we file it? She's like, okay, file it. Like, we file it. She says, nope, denied. Although the parties have focused much of their attention on good cause shown, there remains the question whether a federal officer defendant can ever remove a state criminal prosecution after he's been tried and judgment entered. Now, as already noted, like, is the case closed? It's over. As noted, this question relates to the merits, and there may be viable arguments from either side to permit removal at this stage, or it could prohibit it. We're not going to answer that question now because the district court didn't address it either. So she needs to go decide that on remand, and both sides need to brief this to decide whether this is moot or not. It hasn't even been decided. She didn't even consider it. Now, by contrast, we're going to let her deal with that, but we're also going to address the meaning of good cause. In defining good cause, we draw on the definition. Although not necessary to our resolution on this appeal, we are mindful of two background principles. One, that federal officer removal is not narrow or limited. Okay, this is the Cuomo case, who just got obliterated by Mamdani, walking around New York now, just kind of contemplating his existence. But second, the Supreme Court has also said that the statutory procedures for removal should be strictly construed, and respect for the limited jurisdiction of the federal courts and the rights of the states compels us to resolve this interpretive doubt. Okay, so there's like a tension here. Federal officers, their power of removal is not narrow. It's not limited. It's broad. We want to protect our federal officers, but there's a process to do it, and they got to stick to that process. If they go outside the process, then they can't do it. So there's this tension. Does he have the right to remove it? And did he follow the process in this little tension? Now, here they continue explaining. We interpreted in prior cases the term good cause under the rules, and we looked at all of these cases. We also looked at the federal rules of criminal procedure. Here's another Second Circuit case from our precedent. We have Alexander versus Saul, lots of case law and rules. And as we go through all of that, we analyzed all of this and this and this and this. As applicable to this case, we consistently read the good cause standard to require movements to demonstrate that circumstances out, in this case, Trump, to demonstrate, hey man, there's circumstances outside our control. We couldn't have filed this within 30 days because we didn't even know that there was a Supreme Court decision that was going to be coming down any minute, and it did. Now, in defining good cause to permit the filing of this, we see no reason to diverge from our past interpretations. And so we therefore hold that a criminal defendant, in this case Trump, who moves for leave to file an untimely notice must show at least two things. One, circumstances outside his control occurred. Supreme Court decision, he didn't control that, including if there are new grounds for removal that he could not have raised before the 30-day deadline. He didn't have a decision. That prevented him from seeking timely relief. And number two, after he got notice, oh, I have all this new power now, thanks to the Supreme Court that dictated that, has always been the case. He sought and acted with reasonable diligence to file the petition. And he did. Now, of course, course, we also keep in mind that in other contexts, good cause also reflects a flexible standard. You got to consider a bunch of things. Another Second Circuit case, and the court can go through that analysis. But the district court cited two reasons for denying Trump's motion. The first one requires little discussion. The second one we'll dig into. But they write, first, the lower level judge improperly invoked one doctrine called the Rooker-Feldman doctrine. She said, we don't have any jurisdiction to hear your arguments. They say, what? That case concerns the limited circumstances in which the certiorari statute precludes a district court from exercising jurisdiction in certain cases. Now, because this doctrine implicates statutory rather than constitutional jurisdiction, it doesn't bar a district court from exercising jurisdiction over properly removed cases. So it was error for this judge to say, I can't hear your case, right? She cited this doctrine. She's like, well, this case law says I can't hear it. What? Yes, you can. They said, you're not even reading the case right. Now, the district court's second, also independent basis for denying Trump, she said, well, the Supreme Court didn't say anything different. Nothing in the Supreme Court's opinion affects my previous conclusion that hush money payments were private, unofficial acts outside the bounds of executive authority, and you haven't shown any good cause. That's all she writes. Now, while acknowledging the decision, the lower level judge, who's wrong, does not appear to have adequately considered the Supreme Court case and whether that a change in the controlling law, which is what they said in the SCOTUS, I don't think they changed anything. I think it always existed. There was immunity. We just didn't have psycho prosecutors at the state court level who would weaponize their offices to attack the presidents. Just hasn't happened yet. So the Supreme Court had to come out and say, obviously there's immunity, idiots. As noted, a state court action brought against a federal officer may be removed if there is a colorable federal defense. That's it. So a question that naturally arises in connection with a good cause inquiry that the judge should have done is whether Alvin Bragg's prosecution of Trump ever related to his official acts as president. In urging the answer yes to that question, Trump says, yeah, they did. They brought in all sorts of official acts evidence against me that I'm allowed to do. They used it to imply and impute my guilt. Said that the state, Alvin's office, improperly relied on at least three categories of official acts evidence that is all later precluded by the Supreme Court. First is the testimony that Trump, they came in and testified, they said President Trump, as the president, allegedly told Michael Cohen that an FEC inquiry would be taken care of by the Attorney General. And of course, Trump can talk to his Attorney General. Trump can talk to his lawyer. Trump is the president. He's allowed to do all those things. That testimony should be immune, meaning it should not come in. Now, second is the testimony from Hope Hicks, as we mentioned, White House comms director. She was asked specifically about private conversations with Trump about matters of public concern. All these allegations are coming against the president. Happens every day right now. Oh, Trump's crypto and Trump's with Qatar and Trump's airplane, whatever, constant nonsense, right? And the president can respond to those things, just like in this one. Hey, there's an allegation that you paid off a porn star. Did you? No. And here's why. And they used that all against him. Hope Hicks, what's the strategy? How do we respond to these media attacks? All part of the job. They also brought her in. They had her testify about Oval Office conversations. And third is another category, Trump posting on X on Twitter. He was offering official communications from the White House in response to these allegations. He's allowed to do those things. All of those were official acts. All of those were brought in as evidence against him, and they shouldn't have been. The federal removal statute, he says, protects me against claims when I can make a defense that's based on federal rights, in this case, immunity. Decisions interpreting the statute after its enactment, they also held that the color of office test shows that there's a causal connection, and other laws are all being fleshed out here. 2011 amendment, this other case in 2011, that was another 2023 case. Meanwhile, Supreme Court has also offered guidance as well. But whether the new Supreme Court case constructed a new road for removal turns initially on whether any of those three categories we just talked about actually relates to immunized official acts. So if so, they're not going to decide it here for us, but the judge should respond to those things. If so, there remains the question whether admitting that evidence, whether it transformed Alvin's corrupt case, state case, into one that relates to acts taken under the color of the presidency within the meaning of the removal statute. There are other substantive and procedural legal questions also raised by this. Remember that the federal laws say that there needs to be a colorable federal defense. You can make the argument for one. Were the state prosecution by Alvin somehow related to his official acts, the lower level court would have had to consider whether a challenge of that evidence is a federal defense, or more broadly, whether the Supreme Court decision or changes in the state's theory of prosecution might recreate Trump's federal defense based on preemption under the FECA. Remember that? And Alvin came in at that lower level evidentiary hearing when the judge was rejecting Trump and said, we're not even going to talk about that. No, the FECA has nothing to do with our case. Then he ran his mouth all about it in his closing arguments. Now, even if Trump could establish new grounds for removal existed that he could not reasonably have raised at the beginning, he would have to demonstrate he acted diligently and without undue delay. Otherwise, there is no good cause. Okay, so it's got to be something new, and he acts quickly. Now, the state says he did not act with reasonable diligence. They say he waited more than 2 months. That's a long time. So he needed to go faster. They say he should have exercised diligence and sought relief immediately. Trump says, what? That's it? 2 months? My delay was perfectly reasonable. The Supreme Court just issued a major decision. We filed 2 months later. We had other urgent legal matters requiring the attention of the legal team, like running the country and winning the presidency. So it was very reasonable. Now, at oral argument, however, Trump acknowledged that he could have sought removal immediately, but they opted to instead to give the state court judge an opportunity to address this. They said, hey, we only filed for removal again after we went back to Judge Merchan and said, you now have to dismiss this. You should have granted us immunity and precluded all of that evidence from coming in, and you didn't do it. So now you can correct your error, Judge the Khan, and dismiss it. And he says, no. They said, okay, fine. Then we're going to take it up for removal. According to lawyers, Trump sought removal only after the state court suggested that we're not going to reject your immunity argument and we're going to sentencing. So it's like, oh, okay, well, that makes sense. So you tried to handle it here and now they're not. So okay. So in its denial, however, the district court did not even talk about this, whether Trump acted diligently. In fact, the district court did not grapple with any of the central issues that we have identified above. What a terrible judge. Didn't even care. Came in, she was out having tea or whatever, and just said, denied, denied. She explained only in her decision that nothing in the Supreme Court's opinion affects my previous conclusion that these are private, unofficial acts, and that's it. The court bypassed what we consider to be important issues bearing on the ultimate decision on the issue of good cause. Now, as here, where the district court failed to consider the relevant factors and we cannot determine whether it abused its discretion, the usual practice is to send them back down to the judge. Both parties at oral argument, both Bragg and Trump, they helpfully acknowledged that if we were to conclude that the district court did not properly exercise its discretion, this court could remand it back down to her. And having determined that she did not address significant issues that are relevant to this entire case, we vacate her decision. Gone. And we remand it for development of these and other relevant arguments. So it'll go back down to her and I'm sure she'll rig it again. But specifically on remand, the district court should consider the factors relevant to determining the good cause listed above. And they're basically saying there's good cause. Like they fleshed out Trump's entire argument. This presumably would entail closely reviewing the 3 categories of evidence that Trump claims were in there and determining whether, in fact, the state's use of that evidence means that the president was being charged under the color of the presidency, as the Supreme Court just found. And of course it was. If the district court finds that the prosecution is related in this way, it should then evaluate whether both Trump has a colorable federal defense and whether he diligently sought removal. So she's got a couple of options to deny him again, but they'll just take it back up and say you were wrong again. The district court should also determine whether removal under those statutes is even available at this stage of the proceedings. Now, we leave it to the able and experienced district judge that you guys just reversed for not even considering any of the key factors of the case, whether to solicit further briefing from the parties or hold a hearing to resolve this. We express no view on this and neither rule nor imply that she should resolve this in any particular way. So she can do whatever she wants with it, but she's dead wrong in how she handled it the first time. And so we simply direct the lower judge to consider anew in light of this opinion. And so for the foregoing reasons, we vacate this judge's order denying the request of Trump to remove this, and we remand it right back over to her desk to do it right this time. And we understand what she's going to do. Okay, she's going to deny it again. Trump's going to appeal it again, and around we go. Now, the president was out yesterday and he was saying, you know, we got a real problem here with all of these prosecutions against me and the crimes that were actually enabled by the Biden goons, and was explaining that the auto pen pardons are invalid. And so the federal courts now hopefully going to be stepping in on the Alvin Bragg case, taking that away from them as they should, and vacating all those convictions at some point. But similarly, we've got to talk about prosecutions of the people who are part of this corrupt attack. Matthew Colangelo left the DOJ to go collude with Alvin Bragg. We know that Jack Smith was colluding with the J6 committee. They all got pardons. Then, in our opinion, Jack Smith passed it off to Fani Willis after attacking Harrison Floyd and many other people down there. So the list goes on and on. Now Trump is saying it's time to turn the tables on them.
You know, I get these guys come in with these big, beautiful documents, gorgeous, beautiful, must cost a fortune. I should check the price. But, you know, a general is being made or something, you know, some big post. And they say, sir, would you sign this, please? It's going to be a 4-star general, or it's going to be a big cabinet position, or it's going to be something with medical or whatever. I take my pen and I sign it. In his case, they walk it into a room and they give it to somebody who's no idea who Biden is. But Biden doesn't have any idea who he is either. And they have a machine sign it, the auto pen. And all of the pardons, he gave thousands of pardons to people. He had no idea about it. He didn't know about it. And therefore, all those pardons are void. You know, you have to have, it's a very complicated thing if you're going to use a machine. You have to do it properly. And he didn't have any idea what was happening. And this is what we had as a president. We don't want that. You have the opposite right now. I don't want to be braggadocious, but you have the exact, I know exactly what's happened. If you want to see what congressional Democrats wish to do to America, just look at the result of yesterday's election in New York, where their party installed a communist as the mayor of the largest city in the nation. Remember, I've said we will never have a socialist elected to any post in our country. I used to say that, and I was right. We skipped socialist and we put in a communist instead. That didn't work out too well. But as I've warned for many years, our opponents are hell-bent on turning America into a communist Cuba or socialist Venezuela, and you see what happened to those places. For generations, Miami has been a haven for those fleeing communist tyranny in South Africa. I mean, if you take a look at what's going on in parts of South Africa, look at South Africa, what's going on. Look at South America, what's going on. You know, I'm not going to, we have a G20 meeting in South Africa. South Africa shouldn't even be in the G's anymore, because what's happened there is bad. I'm not going. I told him I'm not going. I'm not going to represent our country there.
All right, so the auto pen pardons are a joke, and the DOJ, of course, investigating many of those people. We're going to keep our eye on this. The Trump prosecutions now stalling out even more after the removal battle continues, and we'll see if they take this case away from Alvin Bragg's state courts, where it was being conducted by Juan the Con Mercan, the guy who gagged Trump, didn't want anybody talking about his Democrat daughter, the guy who donated multiple times to Joe Biden and stopped Trump Republican PACs and all the things, kept the case, rigged the prosecution against the president, and now there's some oversight happening. So we'll keep our eye on this one, my friends. Thank you for subscribing and joining as we do.